Well, it is good to be back home in my Michigan office. As you know, I was traveling last week, and that's why some of you are noticing the different background, the virtual backgrounds. Where is he now? Where's Brother Counsel recording? And maybe that got more attention than actually what I was saying in my videos. But nevertheless, I am back, and it's perfect timing because we had the Karen Reed hearing this morning. And this was the Karen Reed's motion hearing regarding her request that the judge should order the Commonwealth to reimburse her for the $12,000 that she spent to this expert. She had to pay this expert to come all the way to Massachusetts, travel in there, stay overnight, go to the Canton Police Department, and then for no reason, for no purpose at all, because everything was overwritten and there's no logs to even recover. There's nothing there for this expert to do. So this is just one big waste of time and money, and therefore Karen Reed should not have to foot the bill for this expert. Okay, so we got that hearing. And if you're able to join us for the live this morning, appreciate it. We had a good time. But if you were not, then this is going to recap what happened during that hearing. Before what the judge went into the actual motion hearing, first she made a ruling. And this was an important ruling that we're all waiting on. And this was, as you remember, a couple weeks ago, I think it was maybe last week even, there was a motion regarding Richard Green. And the Commonwealth, Hank Brennan, wanted to strike Richard Green as an expert because he should not be able to testify because since, after all, Celebrite came out with a new version, and the new version, it removed the timestamp when that search for How Long to Die in Cold happened. Well, now that it removed the timestamp, well, Richard Green cannot testify that Jennifer McCabe did that search at 2:27 in the morning. Now, even though he used multiple other softwares, which all say that she did do the search at 2:27 in the morning, but since Celebrite doesn't, and Celebrate removed it with this new version, and I don't know if both versions are on the market now. At one point, both versions were, where one version was saying that there was a timestamp, and there was another version saying that there's no timestamp. So at one point, they were both on the market. Could be by now they're not. But either way, that was the basis essentially for Hank Brennan arguing that Richard Green cannot testify that search was done at 2:27 in the morning. And therefore, if the judge is not going to allow, if the judge is not willing to grant his motion to outright exclude Richard Green, well, then they should have a Daubert hearing. And we all know what a Daubert hearing looks like after we've seen what happened with Dr. Marie Russell. So the judge said that she's not going to have a Daubert hearing. So there's no Daubert hearing. There's no way that Hank Brennan's going that Hank Brennan can attack his qualifications or his methodology, although we may hear that during the trial. I mean, that's fair game during the trial, of course. But in terms of a Daubert hearing, that's not going to happen. So the judge made a ruling today. Judge Cannoni ruled that Richard Green is going to be allowed to testify, and the argument really is just about his opinions, and they just don't like his opinions, and they want to argue against his opinions. That's all stuff that should go to the jury, and that's arguments you can make to the jury, but the jury is going to be ultimately the ones to decide who to believe. And that was exactly what Robert Alessi's argument was, if you remember at that time. So she essentially agreed with Robert Alessi, and she's allowing Richard Green to testify. So we're going to have Richard Green testifying, and he's going to testify that Jennifer McCabe did that search at 2:27 in the morning, which is going to, of course, add some more reasonable doubt to the Commonwealth's whole theory. So again, that's a big win for the defense. Now, let's get into the actual motion hearing. So Alan Jackson got up, and he was going to argue that Karen Reed should get her cost reimbursed by the Commonwealth. Now, something that I mentioned, something that if you are a viewer of this channel, probably you may have not gotten this from any other channel. And that is that if you looked through the motion, which Alan Jackson filed, and you looked through the response, I made a mention about this, and this is very important. You have to tell the judge why the judge can give you what you're asking for. This is the very basics of motion practice, okay? You got to cite authority. You got to say, Judge, the reason why you're able to do what I'm asking is because this case says that you can. Now, if you look through the entire motion, people are wondering about this. So if you look through this entire motion that Alan Jackson filed, and I don't know if he was one that actually wrote it, or Elizabeth Little wrote it, or some other associate wrote it, or maybe some law clerk. I don't know who wrote it. I don't know who reviewed it. But something that I noticed is that although there's a number of citations to authority, and yes, there are a number of citations to authority about preservation of evidence and the prosecutor's duty, and that you have to turn over this stuff and disclose it. Yeah, some great citations there, which we're probably going to see again in their eventual motion to dismiss, which is going to be filed soon. But something that was glaringly missing to me was the actual authority which gives the judge the authority to impose sanctions like this. You got to find somewhere where there's a case that says that a judge could force the Commonwealth to pay for expert costs, or if not for expert costs, at least somewhere where the Commonwealth is forced to pay for certain costs, any costs. And that was missing from their motion, and something that I pointed out, which is why I said that if you're Alan Jackson, if you're going to argue this motion today, what you got to do is you got to right away say, Your Honor, there is case law, there is authority that allows you to do this. We may have not mentioned in our brief. You don't have to mention that to the judge. We may have not mentioned this in our motion, in our brief, but there definitely is authority that allows you to require the Commonwealth to repay or reimburse Karen Reed for her costs. And then you cite to that authority. And if we see, as we saw it play out today, that's exactly what Alan Jackson did within the first few seconds of talking. Okay, so I'm glad that he actually did that, because that's good motion practice. It could be that he looked at this motion last night or whenever it was when he was preparing to argue this, and he said, and realized, oh shoot, we actually didn't do what Brother Counsel said we should do, and therefore he fixed that within the first few seconds of his arguing. So I'm going to play for you his argument, and you'll see exactly what I'm talking about. We'll pull up the case just for a drop to talk about it for a minute, and here we go.
The court started by asking, what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember.
Okay, so what does he quote? He quotes this case called the Committee for Public, let me see what it's called again exactly. The Committee for Public Counsel Services versus Attorney General. So if you want to see if Brother Counsel is actually correct about this, you can go check. So most likely you've got that motion that he filed. And now you just heard himself. You just heard Alan Jackson quote this case, Committee for Public Counsel Services versus Attorney General. Go look through the motion and tell me if that case appears anywhere in that motion. It doesn't. So it's a good thing that they realized their mistake, and that's why they fixed it by right away arguing this case, which they're going to argue to the judge, does give the court authority to do what they're asking for. That's why he started off with it, and that's just something that you get from this channel, which most likely you're not going to get from other channels. Okay, let's continue.
What was, I think, pretty widely known here in these parts, which was the Reimburse scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today and really the only question before the court today is, has Ms. Reed suffered any prejudice?
Okay, so now he's going to move into the other parts of the argument, but you see why right away he wanted to right away tell the judge that you do have authority to do what I'm asking for, because he probably realized, look what I said, that they did not cite to that authority. Now, I want to show you exactly where he was citing from that opinion, because it's a lengthy opinion, and I think it's interesting to see where he's citing it from. Okay, because that also kind of gives you a little bit of an idea of the strength of the argument. But let's just pull it up, and I'll show you. And this is, anybody can do this, by the way. This is not like genius Brother Counsel doing this. Is like you heard the citation. He quoted verbatim what it said, and now you can actually see from where in the opinion he was citing it. So you can pull up the opinion if you want yourself. And here it is. This is what it says. Okay. This is a footnote. So you see, this is exactly what he was quoting from, what I highlighted right here. The Attorney General does not dispute that the court has the authority pursuant to Mass Rule Criminal Procedure 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. It's exactly what he just quoted. And they said, see, Commonwealth versus Frith. Okay, so Commonwealth versus Frith also says the same thing, that for failure to comply with discovery violations, the sanctions may be imposed for failure to comply with discovery obligations. Okay, so that's exactly what that case stands for. Those two cases stand for that there is an ability for the court to issue sanctions. I thought it was just interesting that he's citing it from a footnote. Obviously, I'm not going to say the footnotes don't have any authority. Footnotes are definitely authority. But if you can always quote from the body of an opinion, not the footnotes, it's always better. But at least he is citing some authority. Okay, so this authority exists, to say the least, right? It does exist, and therefore that's important to let the judge know that we may have not, again, he didn't say this, but this is what he may be thinking. We may have not mentioned this in our motion, in our brief, but it does exist. So therefore, Your Honor, we can go on with this motion. Now, of course, if you are Brennan, then you can be arguing back, well, Your Honor, he didn't make this argument. He made a different argument, which we're going to discuss also. But you could argue back, well, Your Honor, this is a case that he's just bringing up now. The reason why you file motions, the reason why you file briefs is so that we don't have these type of situations where somebody just gets up there and starts citing authority, which I don't have the ability to research myself. I don't have the ability to shepherdize. I can't argue against that case that he's citing because I didn't read it. He's just bringing it up now for the first time. And therefore, Your Honor, you have to completely ignore that case, and you should only base your rulings on what you know he filed in the motion. And if he didn't cite this case in the motion, well, Your Honor, you should completely disregard it. Now, he didn't argue that, Brennan. He went more to the substance of this argument, which we're going to talk about soon. But nevertheless, I think this was a mistake. And I mentioned this in the first thing. I know people don't like to mention when I show you that Karen Reed's side made some mistakes, but this is a mistake. They did not mention this case in their motion, did not mention this citation to authority, and wasn't made a big deal about. And Judge Canoni, and I know just some judges that can also make big deals about this. They can say, you can't make this up now, Mr. Radner. Not that this ever happened to me, but the judge can say, you can't just bring up new cases now. We have to all research it. That's why you file motions before. Okay, but we'll see. I think he may have gotten away with it. All right, so then he continued and he started talking about this preservation. Right now, there was a request for preservation by David Yannetti all the way in the beginning of the case, and this preservation happened in February 2nd, 2022. Okay, that's right away after this. Within a week, this motion was filed by David Yannetti. And again, if this system doesn't overwrite itself until for 30 days, then there's plenty of time for the Commonwealth to preserve it. Now, even if there's no preservation order, which is a point that was made, that I made, that Jackson made during this oral argument, there is no requirement for there to be a preservation motion. There's no requirement for there to be a preservation order. There's no requirement to be a formal request, an informal request, nothing. You can sit in your office with your feet up as a defense attorney, and still the Commonwealth is required to preserve this evidence. So this is really beside the point. They're still arguing it because it came up in the motion, and that's something that he mentioned right away, Alan Jackson. He said, I can't believe that Hank Brennan mentioned in his response that we never made any formal request. We did make a formal request, and even if we didn't make a formal request, by the way, it doesn't matter. So we did make a formal request. It happened in February 2nd, 2022. Now, this became an issue because the judge said, well, you didn't file it in my case. In my case, you didn't file it. Now, it seems like there was actually a filing that was made in this case, and I just saw someone who posted that maybe that motion was denied for some reason. I'm not sure exactly why. I didn't get to see that motion. I don't know what happened there, so I can't opine about what happened and why she denied it. But there was another motion to adopt all these new motions that he filed in the other court, and that's what happened. And then he filed this in Stoughton, and then this preservation request. Not that it should make a difference. The point is that the Commonwealth had notice of this preservation request. It doesn't matter which court you filed it in. They have notice, and they have an order from a judge saying that you got to preserve it. So, and even if you don't have an order from a judge requiring to preserve it, you still have to preserve it. So this is just like, they're arguing about, whether there was actually a motion or not, even though it's not really so relevant to what they're seeking. Now, initially, Yannetti said that he actually attached this as an exhibit, because he got up there for a minute to clarify what was going on. And he said that he think initially that he did attach it as an exhibit, but then there was apparently some sort of motion that he also filed itself. I saw somebody post it, and there was some sort of motion that he filed to adopt all the motions that he filed previously in the previous court. Now we have to get some more clarification about why that order was denied. Okay. And then he starts talking about this DVR. Okay. And it was very interesting. Again, this DVR officially overwrites itself every 30 days, right? So let's just assume that it overwrites itself for 30 days. And I think this is going to be much more of an issue in their eventual motion to dismiss. Now, you got to remember what we're here for. But anyway, let's just talk about this because this is what came up today in the hearing. So this DVR, which is the original video that's recording the Sally port, officially it overwrites itself every 30 days. Okay. Now, if that's true, how is it possible that they keep getting new pieces, like piecemeals of this video? You know, right before trial, they get a video, and then during trial, they get the inverted video, as we all know, and then it's inverted. And now, even after the trial in October, they get a video of Brian Higgins at 1:35 in the morning outside of the Canton Police Department on his phone. And this is after he testified that he didn't make any phone calls that night. And the only phone call that was made apparently was a butt dial, as we all heard numerous times. And in fact, something that Alan Jackson pointed out is that in the federal grand jury testimony, he also testified, Brian Higgins that is, that he made no phone calls. And now they have a video showing Brian Higgins making a phone call on the phone at 1:35 in the morning. Now, if I just had to guess, okay, if I just have to speculate, and this is complete guesswork, and if Brian Higgins is going to be confronted, then you can be assured that he is going to be confronted with this video, and he's going to be impeached when he's on that stand a million times, saying, how many times did you tell everybody in the federal grand jury? You're not able to say federal grand jury during the trial, at least in the last trial, probably in this trial also. But in a previous proceeding, how many times did you say that you did not make any phone calls? How many times in the previous trial did you say that you did not make any phone calls? On direct, on cross, and now we got a video of you making a phone call. So he's going to be impeached every which way on this. But I would have guessed, and I'm just laying on a limb here, I would guess that he's going to say that maybe he was checking voicemail, or maybe he made a phone call that nobody answered, and therefore he didn't feel like that was important to tell you because there was no conversation. That's just what I imagine, but it really, really, really doesn't look good. Really, really doesn't look good. You know, who are you calling at 1:35 in the morning and that you conveniently told everybody that you're not calling? And that you told everybody you didn't make any phone calls. And as much as you try to explain that away, it's not going to be good. You know, so, but that came out. That was another part of this video that all of a sudden is appearing. So if this DVR overwrites itself every 30 days, and whatever you copied as the Canton Police Department, you copied this over to a different hard drive or cloud or whatever it is, and then you're sharing it with the defense, and all of a sudden there's just different pieces that are coming at different times. What in the world is going on? I mean, really, honestly, what in the world is going on? How can we have any confidence about what you do have and what you don't have if we keep getting different snippets of videos that you forgot to give us before or are just appearing somehow? And now on top of that, you've got this new detective who was mentioned, this retired detective, retired sergeant in the motion. This was actually spoken about in the motion. And now he has a copy of the footage. He routinely makes copies of the footage. So what type of policy and procedure is there in Canton Police Department? I hope this is brought up in the next trial. What type of policy, please, is there about recording videos of vehicles that are involved in homicides or any sort of evidence that comes in that there's recordings of? What type of policies and procedures are there in place? Are there any? And how was that followed in this case? Was it not followed? You have this new detective all of a sudden saying, yeah, I save it to some cloud. Where's that cloud? Is that cloud protect? Like, is this your personal computer? What in the world is going on? So this is another issue that keeps, the more you go on with this case, the more you dig, the more you get these interesting issues, coincidences or anomalies. So you got this new detective now. Okay, so that's another argument that Alan Jackson made, and therefore, you know, when their expert came, and they, you know, he went through some of that. When their expert came, and then there's nothing to get, and they just wasted all this money. So therefore, all of these actions to therefore require the Commonwealth to reimburse Karen Reed. Now, something that Brennan brought up, okay, and something that I think a lot of people are going to miss because he made a quick mention of it, and really it's not to this whole story about what happened. And again, it has to do with the case, which is important. Like I tell you, you know, the case law at the end of the day is important. So you guys remember, I just pulled this up before, but which case did both Alan Jackson and Hank Brennan talk about? They spoke about this other case, and I know it's a little small, but this is a footnote after all. Commonwealth versus Frith. Okay, this is in the footnote. Now, although the footnote does say the Attorney General does not dispute the court has the authority And this was some tremendous scandal that went on over there in this case. Okay, this case that the footnote is on. The Attorney General does not dispute that the court has the authority pursuant to impose remedial monetary sanctions for discovery violation. See Commonwealth versus Frith. Now, Commonwealth versus Frith, Hank Brennan said, actually, that case, this is what Hank Brennan's argument was, that case actually tells you that in that specific situation, it was not egregious conduct. And that even though the court in Commonwealth versus Frith initially required sanctions to be paid by the Commonwealth, it was overturned. So it did not rise to the egregious conduct. So the question here is, what's the egregious conduct that we're arguing about for the purposes of this motion? And this is an important part that Brennan kept stressing. And this is important. I know that it may seem like semantics, but it's actually important. Okay? This is how it goes. What you name your motion and what basis you bring your motion under is what the court is going to review your motion under. So, for example, let's say you file a motion to compel discovery. Okay, now in that motion to compel discovery, you lay out reasons why this case should be dismissed. Okay, so again, the motion is a motion to compel. You want discovery. But in that motion, you cite a whole bunch of reasons why this case should be dismissed. And you give the whole background. Explain how terrible the other side is being, how egregious their conduct is. But for the purposes of this motion, it's a motion to compel. So can you get up there in front of the judge and say, Your Honor, this case should be dismissed at the hearing? This case should be dismissed. And look at everything that we've argued about in the motion. Look at all this nefarious conduct. Look at all this egregious conduct. And the law is clear that you are allowed to dismiss a case when you find this type of conduct. Let's say you do that, okay? If you do that, your motion is going to be denied. You know why? Because this is a motion to compel. That's how you wrote it. That's how you labeled it. And that's the basis that you're bringing this motion under. Now, even though you throw in there that there's maybe reasons to dismiss the case, the judge is not going to entertain a dismissal because that's not what this motion is all about. So what Hank Brennan was arguing is that these arguments, a lot of these arguments about whether this video was properly preserved have absolutely nothing to do with this motion. It has nothing to do with the motion of why we're here today. This has everything to do with the Brady violation and the Rule 14 violation. And that we know from a footnote in the motion, on this motion, that they are going to file. We know all about that motion to dismiss. They're going to file this motion. Don't worry, we know that. We know it's coming. And in fact, the judge actually kind of changed the scheduling, which we'll talk about. But yes, this motion to dismiss is coming based on Brady violations and based on not preserving evidence. We all know it. Okay, that's great. That has nothing to do with this motion. This motion is to reimburse the cost of this expert because you're arguing that me, Hank Brennan, I acted with egregious conduct. I was nefarious in my conduct. And what I'm telling you, and what I've filed an affidavit to the effect of, is that I did everything normal. I was accommodating them. I was being professional. I was giving them this courtesy to come down and do and to look at this video. Now, something also that he mentioned was that it's unprecedented. This is unprecedented that an expert hired by the defense is going to come into the police station and forensically download this digital evidence. He says it's unprecedented in his 3 decades of being a lawyer. Now, it may be true. Okay, it may be true that this is unprecedented, but you know what else is unprecedented? Everything else that's going on in this case. Okay, this case is wild. It's crazy. Okay, so maybe there are certain times when unprecedented things have to happen because we can't trust the copies. They're getting inverted. We're getting them after trial even. We're getting the video of Brian Higgins after trial. Can you believe it? So this is all going to be motions. This will be part of the motion to dismiss because of these Brady violations or whatever. But because of the unprecedented other issues in this case, that's why Karen Reed is going to need their own expert to come down there and make sure that no one's doing anything funny or at least trying to discover that. So, but Hank Brennan is saying back, well, at the end of the day, this is unprecedented. And even so, it was so unprecedented, we still accommodated them. So again, if the focus of this motion is my conduct, which is essentially what Hank Brennan is understanding this motion to be, and if you look through the motion, again, if you look through that motion, there's not one mention of, well, I shouldn't say there's not one mention, but they're not dressing this motion up as a Rule 14 violation sanction motion. That's not what they're dressing, how they're dressing up this motion. In fact, we know that Rule 14 violation motion is coming. That Brady violation motion is coming. So Hank Brennan was just arguing that you're conflating these two motions. So that was his argument. And when it and then again, when it had to do with that case of Commonwealth versus Frith, just happens to be that in that case it was not upheld. The granting of those sanctions. Now also, those sanctions were imposed because of discovery violations, because of Rule 14 violations. So again, this is not an issue. This motion is not an issue of why didn't the Commonwealth preserve the video, and they didn't preserve it in the right ways. And there's something crazy going on with those videos. We know that. We know there's some issues there, and we know that that's going to be the subject of a motion to be dismissed based on those procedures or lack of policies and procedures or appropriate ways to download these videos. We know that's coming. But for the purposes of this motion, which is just specifically to reimburse the costs, it wasn't so clear exactly from, again, I don't know who wrote this motion on behalf of Jackson's defense team. I don't know, but I definitely could have been much clearer about what they're looking for, what they're wanting. Not what they want, but we know what they want. They want to get reimbursed the cost, but just how it's laid out. Is this a Rule 14 violation sanction motion that you're filing, or is this some other basis that you're filing this motion? So that's something that has to be clear and has to be done. Now, it doesn't mean that the judge is not going to grant this motion, but we'll see what the judge wants to do with this. Nevertheless, I think, again, the more important issue here is going to be all of this as a Brady violation, as a global, broad issue of we cannot trust these videos. And now that video is lost because they didn't preserve it, and there's no order to preserve it, and you don't need an order to preserve it, whether there is an order or not. Okay, I'm sorry, misspoke. There was definitely a motion that was filed by Yannetti, okay? And that was most likely an order that was entered in the Staunton case. And then it got transferred to Judge Cannoni. So it doesn't matter whether there's a motion or not, okay? Let me just make this clear. It doesn't matter. They have to preserve it, and they have to disclose it. And if they didn't, that rises to a Brady/Rule 14 discovery violation, which is going to be the more important issue in this case. Now, something just to clarify in terms of what happened today. There was this reciprocal discovery with the ARCA experts, as we know, as I've told you. They're making these requests, and they're trying to get some information from the ARCA experts, which they're not going to be able to get, most likely. And therefore, Brennan's going to file a motion to exclude them as well. Most likely not going to succeed in that. But okay, that's what he's setting up for. Now, some of the dates got changed because what happened here was, you'll remember that Brennan at the last hearing didn't turn over all the discovery yet. And Judge Cannoni asked Alan Jackson, when are you going to file this motion to dismiss? I got to know when you're going to file this motion to dismiss, because we got to keep things moving. And trial's coming up on April 1st. We got to take care of all these motions before. So Jackson said, well, I can't file a motion to dismiss until I see all the discovery. So they haven't handed over all the discovery, right? The Commonwealth first has to hand over all the discovery. Then they have to file a certificate of completion, which is supposed to be done today. So last week, obviously, Jackson said, I can't tell you for sure how long it's going to take for us to file this motion to dismiss, because I don't know what type of discovery I'm going to see. Maybe I'm going to see more videos. Maybe I'm going to see more stuff, more things that we didn't know about, and that we're just finding out for the first time now. So I can't tell you for sure with certainty. So if you remember, Judge Cannoni asked Hank Brennan, okay, well, how much more stuff did you not turn over already that you're planning on turning over within the next week? And he said, oh, maybe one or two things, like nothing significant or material or voluminous. And then what happened? So, okay, well, if that's true, well, Judge Cannoni said, well, if that's true, then okay, we can start setting motion to dismiss dates when you have to file your motion, because if there's only two more documents that he has to turn over, whatever, a couple of documents, okay, how much time do you actually need to review that? So that's why last week they set the hearing for that. The motion to dismiss has to be filed by February 11th, and then the hearing was going to be the 18th. Well, today, Hank Brennan said that he actually handed over a lot of stuff. And Alan Jackson said, yeah, there was a voluminous amount. There's a number of different categories of discovery that they handed over to us. So it's not just two papers. It's not just two things. There's a lot of things that now we have to sift through. And that's why Alan Jackson told Judge Cannoni, we cannot file this motion in 6 days. It's going to take us 6 days to go through all this stuff that they just dropped on us, all this discovery that they dropped on us. And only then are going to be able to determine what our basis is for this motion to dismiss. I mean, they already have some basis, definitely, but they want to get some more basis, right? When they have some more reasons why they want to file this motion to dismiss. So that's going to take time. So the Judge Cannoni, she did agree with Alan Jackson and said, okay, we, and Brennan acknowledged that he did drop a lot of documents on them. So now the timing is going to be the following. February 20th is when Alan Jackson has to file the motion to dismiss. February 27th is when the response is due. And the hearing is going to be on March 4th. So the hearing for that motion to dismiss is going to be on March 4th. And that's in terms of the motion to dismiss. And again, like I said, I think that's the much more important and interesting issue. Of course, nobody wants Karen Reed to lose $12,000 for no reason, for a total waste of time. And there definitely could have been things that could have avoided that. Like they could have been very clear that there is no way you're going to find anything from the DVR. That's absolutely true. And perhaps it could have been done a little bit better with a little bit better motion practice. Okay, but nevertheless, we'll see when eventually Judge Cannoni rules on this, and we'll see what happens with the motion to dismiss. So we're going to be there with you the entire time, breaking everything down, explaining it all, doing some research, and don't worry, this is going to be very interesting as this goes on. So that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.